Next case on the docket is Jimenez versus Ortega. Okay.
If it pleases the court, I'd like to reserve 3 minutes for rebuttal.
Okay.
On the spectrum of sanctionable conduct, perjury is perhaps the most egregious. Trial courts have the authority and obligation to dismiss a cause of action for fraud on the court. A system that depends on an adversary's ability to uncover falsehoods is doomed for failure. These are the words of this court and the courts throughout the state regarding the necessity and obligation of litigants to tell the truth. The trial court erred in this case for 2 reasons. First, it applied the wrong law or reasoning when deciding whether Mr. Ortega's claims should have been dismissed for fraud on the court. Secondly, it abused its discretion in the face of numerous and repeated lies that went to the 2 central issues of this case.
Let me just make sure I understand. Was the jury made aware of all of these misstatements and these alleged fraudulent acts that you're complaining about in this appeal? Was that all brought out to the jury?
Yes, Your Honor. There was cross-examination where Mr. Ortega admitted to these lies before the jury.
So the jury heard all of this and factored all of that in when they made their final decision, right?
Well, 2 issues, Your Honor. We don't know what the jury actually factored in.
No, but the point that I want to make and establish in my mind is that the jury heard all of this. Is that right?
That is correct. They heard
and the trial judge who was conducting the trial heard all of this. And so we have the 2 entities, the trial court and then the jury, that heard all of this alleged fraudulent conduct.
That is correct, Your Honor.
And so what you're asking us to do is say that based on that, regardless of the fact that the jury returned the verdict that it did, and regardless of the fact that the trial judge took the action that it did, you want us to say that based on this fraud that
Well, I think the correct analysis for this court and for the trial court is to look at the conduct of Mr. Ortega. The reason why we have these deterrents for dismissal for fraud on the court is to ensure that litigants tell the truth.
The conduct was considered by the trial court and by the jury, right?
Yes, it was, Your Honor.
Okay, all right.
However,
Cases out there where the case has gone to trial and the trial judge has denied the dismissal and the Court of Appeal has overturned?
yes, Your Honor, there's actually a case procedurally directly on point, which is the Martinson versus Dade County case, Metropolitan Dade County versus Martinson, 736 Southern 2nd, 794. And in that case, the plaintiff was cross-examined and her lies became apparent. A motion was brought before the court for dismissal based on fraud. Similar to this case, the court withheld ruling, and then his ruling was reviewed by the appellate court in that case, and they found that it was abuse of discretion for failing to dismiss his case for fraud under the exact same procedural circumstances.
What was the jury verdict in that case?
It was a jury verdict for the plaintiff, awarding damages. And here's
Do you have any other cases besides that one?
There's another case, Your Honor, that's somewhat similar, and that's the Hanano versus Murphy case. That's 723 Southern 2nd, 892. And in that case, a verdict was again awarded for the plaintiff in a very similar amount, about $400,000. There was surveillance of the plaintiff, and during trial, he hemmed and hawed, but it was apparent that he lied in the course of his deposition.
So I think both of those cases say that the trial court acts based on discretion, and we have to determine whether the trial court abused its discretion in this particular case in doing what the trial court did, right?
I believe it's both discretion, but also applying the correct reasoning, Your Honor. If you look on how the trial court approached this, by looking at the jury verdict, the end result, what does it do? It creates an incentive for unscrupulous plaintiffs to not tell the truth, because there's no loss in the end game. Okay, I can lie during the discovery process in the hopes that I do not get caught.
Don't you see, from our point of view, that it makes it a little more difficult for us to say there was an abuse of discretion when the jury heard it all and rendered their verdict anyway, and then the trial judge heard it all and said, well, based on my discretion, I'm going to let the jury verdict stand.
Yes, Your Honor, I understand.
Can you see where that would make it a little more difficult for us to say, well, the trial court abused its discretion?
I don't think so, Your Honor, because I honestly think that the court applied the wrong reasoning in this case and failed to look at the conduct of the plaintiff himself. As I was saying before, if we go with the path of the reasoning of the trial court here, it creates a disincentive to tell the truth during the discovery process. Because, okay, I can lie over years and years of discovery. I can force the defendant to pay endless amounts to try to uncover the truth in this case. And in the end, if they do uncover whatever, then I can just come clean at trial and all is forgiven. It's a reset button. Does this court want to be the court that presents a reset button to a lying plaintiff over 3 years?
Were the lies on topics central to the issues that were being tried?
Absolutely, Your Honor. There are only 2 contested issues in this case as liability was admitted. They were, 1, pain and suffering, and the physical disability of the plaintiff. And the lies, without question, went directly to those 2 issues. And what was Mr. Ortega's motivation? Some lied to cover, not to get in trouble. Some lied to protect. His sole motivation was to mislead this jury or to thwart our ability to obtain discovery so we could have a greater financial outcome from this case. There's no dispute.
Some of the cases say you have to show a scheme, a knowing scheme to defraud. How do you have that here?
Intentional lies are a knowing scheme. When you know that you don't have a pain level of 9 out of 10, or that you can walk more than 3 feet without significant pain, and you lie in deposition, Your Honor, that clearly shows that you're intentionally lying.
Pain and suffering of an individual, I mean, it depends on what the individual says it is, really. And the doctor can say that he should be in pain, but the doctor can never say that, well, he's in extreme pain, medium pain, or lower. I mean, it depends on what the individual says, right?
Your Honor,
that's a hard thing to tie down in terms of a lie about what your pain and suffering is.
And Your Honor, that is an excellent point, and I'll tell you why. Because there's no pain meter that you can put in an individual to determine their pain and suffering. It's purely a subjective measure.
Why shouldn't it be up to the jury to determine that? He said this, he lied about this, he lied about that, but we're going to...
I apologize, Your Honor.
Go ahead.
Because the courts of the state are charged with the duty to protect the integrity of it, to ensure that litigants tell the truth. And by doing that, they have to create an incentive for those unscrupulous plaintiffs that will pursue gains that they're not entitled to. And
Is there evidence in the record that Mr. Ortega also was not particularly truthful with the doctor?
Yes, Your Honor. Another excellent point, which goes to the scheme which he created to try to defraud this court. He lied about what he told the doctors, and he admitted that at trial. Dr. Cole, who was his treating physician, he tried to advise during the discovery process that he advised him of the issues that he was having. Well, with his inability to walk, with his pain level. At trial, he admitted that he never told the doctor of those issues.
Okay, what was the faulty reasoning that the trial court used in failure to properly exercise his discretion? Just tell us, be specific about it.
Based on the case law, I believe the correct analysis for the court to pursue was to look at the conduct of the plaintiff, and in this case, the numerous and countless lies which the trial court was shocked. He actually said he was shocked by those amounts. Because those were told, he admitted to those lies during the trial process, we were given clear and convincing evidence at that point that he had perpetrated a fraud on the court. So then the only question, I believe, for the court at that time was whether the conduct was sufficiently egregious to require dismissal. If you look at the cases which are cited in our brief and the citations that I gave to you at the beginning of my argument, there is no more threat to the integrity of our system than lies. And this was not just one or two lies to periphery issues.
Give us your rendition of the most egregious lies that he told.
His lie, okay.
Start with the very, very worst that you think.
Okay. I thought they were all bad.
Well, any lie is bad, but let's assume there are degrees.
I think that sitting at trial, one of the hottest contested issues was Mr. Ortega's ability to work and his expected retirement date. I think his lies that he was in constant pain when even sitting down was one of the most egregious. I think his lies regarding his inability to walk more than 3 feet was egregious. Because if you look at the contested issues, which is his ability to work and his enjoyment of life, those two lies particularly affected those two issues. And I think they were particularly poignant for a jury. And I'm sorry for interrupting you.
I can't drive, I can't fish, I can't walk more than 3 feet, I can't work. Really,
They were just numerous.
all he could do was breathe.
Exactly, and that's the point I was trying
And
to...
that was painful,
Exactly.
apparently.
He claimed he had pain even while in bed, correct?
He claimed he had pain while in bed just sitting. He claimed he had pain when taking off his socks.
Which could have been true, but he later admitted that all those claims were false. I mean, he had a horrible injury
No question.
and would have had pain and suffering for a period of time. That's not being contested, is it?
Right. No, that's not contested, and that's the irony of Mr. Ortega in this case, because he suffered a real injury, and he had surgery, and he didn't have to lie. But he lied, and he lied because he wanted to achieve a greater financial gain. That was his sole motivation.
What about, there's no question he lied, and in my mind, they were egregious. What about the argument that this all should have been raised pre-trial? You had this information, you had the videotapes of him driving and whatnot, and walking to his mailbox and doing whatever, and that you should have raised this issue pre-trial, and perhaps it would have been a different result at that particular time.
I don't know if there would have been a different result, because I believe that the one impetus for him to come clean was the presence of the jury. So I think it's pure speculation to see.
When was the first time you raised it?
First time was at trial when we had his admissions, and at that point we had clear and convincing evidence.
Before the jury returned its verdict?
No, I think at a directed verdict stage after the...
So you waited until after the jury returned its verdict?
No, that's incorrect, Your Honor.
Well, that's what I'm asking. Tell me
I'm
when
sorry. No, we...
you first raised it.
Yes, we first raised it prior to the jury rendering a verdict after the close of plaintiff's case.
Okay, when you moved for directed verdict.
Exactly,
Okay,
Your
I got it
Honor.
now.
And the court reserved ruling. And the reason we moved at that time was the law of the state has created a high standard for dismissal based on fraud in the court, and you require clear and convincing evidence. Now, this was a person with a very real injury for a while. During some of his depositions, he was in a cast. At that point, there was a great...
So getting back to Judge Berger's question, you don't think it would have made any difference had you raised this pre-trial as opposed to when...
I think it would have been pure speculation, because at that point, Your Honor, the court would have had to hold an evidentiary hearing. And this is someone that did not tell the truth through the entire discovery process, and it seemed that the only impetus for him to come clean was for the fear of what a jury would think of him. So...
Clear and convincing proof that the scheme existed before he admitted that he lied at trial?
No, I don't think there was clear and convincing at that point until he clearly admitted that he lied, Your Honor. When a plaintiff comes forward and says, "I lied," that was not true. That's clear and convincing evidence.
You just have
When you have a video, I'm sorry, I'm sorry, Your Honor.
You have to wonder, what kind of jury did you have? I mean, that's neither here nor there. You just have to wonder. I mean, anyway, the cases that I tried, I mean, once the jury caught somebody in a lie, that was just almost the death knell. But apparently, it's changed today. I don't know.
Well, I may have to take responsibility because I picked the jury. I did the voir dire, so...
Was the strategy the trial strategy of Mr. Ortega from the beginning of jury selection throughout, basically a fall on the sword, we lied and people lie to do things to get things that they want, and from beginning in jury selection all the way through to the end.
That's another excellent point, Your Honor. From the beginning of trial, their strategy was to sanitize the jury to the effect of these lies. During voir dire, they were actually asking questions whether, you've ever over-exaggerated or not were truly forthcoming on an issue to protect yourself or someone you loved. During closing, they asked the jury to, in the face of these lies, consider the measure of the man that Mr. Ortega was. And that's another reason why when a court decides to let these things go to a jury, it creates an uncertainty, because you don't know what 6 individuals are thinking. You don't know the effect. You don't know if they were paying attention when that questioning was going on. What we do know is we have clear law. We have clear language in our court system and in our case law showing when a plaintiff repeatedly lies to the 2 central issues of the case, they forfeit their right to proceed. And based on the conduct of Mr. Ortega, there's no question that these lies went to the central issues of the case. They created an atmosphere where you could not even tell if anything coming out of his mouth was truthful. And at that point, the court was required to dismiss this case. If there are no other questions, I think that I'll reserve my time.
Good morning. May it please the court, my name is Chris Carlisle. I'm here with co-counsel Paul Perkins on behalf of the appellee. Your Honors, there are 2...
Carlisle, there are,
yeah, sure.
It seems to me that, when you look at the totality of the case, you've got a jury that heard everything, yet they rendered a verdict, and the trial judge that heard everything. At least to me, it makes it more difficult to say the trial judge abused his discretion, but that's not really, simply because you have a jury verdict and the trial judge ruling the way it did doesn't necessarily mean the appellate court can't take action to correct the fraud and the abuse that occurred. It just seems to me it makes it a little more difficult, but in this particular case, there are instances where it's just clear that he misrepresented and lied and then told the jury that he did, and the trial court let it go on anyway. So why wouldn't this be a case where we should say the trial court just abused his discretion and should have come up with a different ruling?
Well, there are various reasons for that, Your Honor. One being that there was a clear line of cases from this court that the trial court was aware of and put forth in its order, dating back to Cox, through Ruiz, through Bologna, and up to the Perrine case.
Speaking of Cox, doesn't Cox say where a party lies about matters pertinent to the party's own claim or portions of it and perpetrates a fraud that permeates the entire proceeding, dismissal of the whole case for fraud on the court is proper?
The Cox does say that, Your Honor, but Cox also talks about it being the most extreme sanction that should be used in extremely rare circumstances.
Why isn't this one of those extremely rare circumstances? It seems to me, Mr. Carlisle, that Mr. Ortega lied about everything that was pertinent to his claim. And so I'm having some difficulty seeing how this is not one of those extreme cases.
He lied about things, but he told the truth at trial, and that changes the matter, obviously, and puts it in a different position. Secondly, if you look at the cases, well, there's 2 overriding principles.
Cheating spouse, it does whatever they want to do until they get caught, and then to try to save themselves, they fall on the sword and please forgive me for my sin.
Well, Your Honor, again, the alternative would be for him to continue lying during trial, which we would submit obviously would be worse. He did come clean during trial, but the overriding principle that was set forth by this court over and over was talking about even in cases of misrepresentations, and in Bologna and in Perrine, it talks about even when they're engaged in lies, even dissemblance, even lying, could be well managed through cross-examination, which is what occurred here.
Here, I think what the concern is that these were the essential elements of his cause of action that he was lying about.
Your Honor, again, I think it goes back to the concept you raised earlier about
These
scheme.
were not, it didn't seem to me like these were not periphery issues.
These were the extent to which he was suffering. But I think if you look at the cases, not just the line of cases from this court, but all the cases we're talking about, again, going back to it, you are correct. The overriding principle is the broad discretion afforded the trial court in these instances. But secondly, the concept of a scheme, which was mentioned earlier. If you look at the cases going back, generally these cases deal with situations where there was lying that dealt with medical injuries in the past and trying to deny the defense access to certain medical records and doctors, saying, I'm not going to tell you that my knee was injured twice when it was done. And there's a line of cases that deal with that. It's slightly different than what we're talking about here. And I think that this court's repeated examples of talking about dissemblance and even lying as opposed to that scheme, denying access to medical records, denying information about what happened to someone previously. And again, how do you measure pain? He admitted it, I lied. And I think it's...
But it
Yes, Your
wasn't
Honor.
just about the pain. He lied about his abilities. He said he could not walk without a cane.
Absolutely.
He said he couldn't go up and down curbs, couldn't climb stairs. So he lied about his level of pain, which is, understandably, if he said, well, I said 5, maybe I was wrong, but he lied about his level of pain. He claimed pain when he admitted later that he had none. He lied about his ability to walk. He lied about his ability to lead a normal life. He claimed he couldn't go over to his, I can't remember if it was a relative or a buddy, but, I'd have to go in a wheelchair and because it's a cultural thing and so on. I'm having a lot of trouble, and help me out here. This is a good shot for you to come in here.
Okay.
The Hanono, I guess that's how you say it, versus Murphy case, out of the 3rd District, there the plaintiff lied in his deposition, just like the plaintiff here. The plaintiff then claimed he came clean during his testimony, and the trial court apparently said, okay, you came clean enough during your testimony and we're fine with that, but the 3rd District Court of Appeals said no.
And again, there is a discretion, there is a call in this court to determine whether the discretion was abused. And I think that case, and also the Martinson case out of the 3rd, take a slightly harder line on this. And I think, again, when you're talking about this trial court, in this case, those cases weren't cited to him, by the way, at trial. There was no motion for new trial arguing Martinson should apply or that case should apply. There were a couple cases given in the middle of trial to him to make this decision. He was aware of the cases from this district, which, again, have slightly different language and don't take quite as hard a tack. Therefore, can we say that no trial judge in the state or anyone, any reasonable trial judge would have done what this trial judge did, given the precedent of this court, and those were the only cases that were given to him during the middle of trial? So I think, again, the
arguments were being made.
The arguments were being made, but again, I think that the distinction in this case, again, no one is condoning this behavior, and believe me, it's an unfortunate circumstance, but the reality is, what happens here? You had a case that went, they knew about this, and the trial court, again, I think it goes to the discretionary call of the trial court here. They knew about this stuff. The trial court learns about it after the plaintiff rests the next day. There has been a jury picked. We spent days getting to this point. Is it reasonable for the trial court at that point, in the exercise of his discretion, to say, I hear what you're saying. I get it. I don't like this. This guy lied for an hour. I heard it all yesterday, but I'm going to reserve on this. And why are we going to reserve? We're going to see what the jury did with it. And if you look at his detailed order, which was not cited to this court by the other side,
But isn't
he
it
goes through
incumbent
this.
on the trial court to make a decision and not to take a wait-and-see approach to what the jury's going to do? Because if there's fraud on the court, that you shouldn't even let it get to the jury at that particular point, which goes to the argument that counsel made that the trial court applied the wrong standard.
That argument was not raised below, and it was not raised in their initial brief, as far as I can tell, and I don't know where that argument actually, I think there's some reference perhaps in the reply brief, but 2 points on that. Number one, when the court says, I'm going to reserve till after the jury comes back, there was no objection to that. There was no argument saying, you're applying the wrong standard, Judge, you need to decide now. Secondly, there's no cases on that. The court has discretion in this case.
The trial judge certainly has the right to do that. I mean,
Absolutely.
It seems to me that once the jury comes back with their verdict and the jury's heard it all, it makes it much more difficult for the trial court to take it away. That doesn't necessarily mean that the trial court didn't abuse his discretion.
Correct, But I think you also have to look at what occurred here, and I think it was appropriate for the trial court to say, listen, I heard him lie, the jury heard him lie, as you mentioned, Judge Shalaya. What did the jury do? They heard this. What did they give him for future pain and suffering damages? Zero. Zero.
He admitted he was not in pain at that time.
Opposing counsel argued to the jury they can give him up to $25,000 for that, and the jury gave them zero.
At trial, the argument was he wasn't going to have any future pain by himself. He wasn't in pain at the time. So it would have been rather surprising for the jury to give him anything for future.
And perhaps if the jury had given him something or given him the $25,000 as suggested by the other side, the trial court should have said, you know what, I'm going to go back and I'm going to actually dismiss the case because this obviously is inappropriate.
Know that the jury gave proper weight to the lies, the 3 depositions versus coming clean during trial. How does the trial judge know that the jury got it right, and how do we know that the trial judge was exercising proper discretion?
The trial judge, none of us can look at a jury verdict and know what goes on in the jury room. However, none of us sitting in this room, well, I apologize, none of the 4 of us were not in that courtroom. The trial judge was, and the trial judge had the ability to see the effect of all this testimony on the jury. He had the ability to see what was going on in that courtroom from a perspective that we do not. And to suggest that...
Is there a presumption that the jury verdict, kind of like the judgment that is founded on the jury verdict, is kind of clothed with a presumption of correctness until it's proven wrong, and that there's also a presumption that the jury follows the jury instructions to properly weigh the evidence and that sort of thing? Is there a presumption as to that or not?
I would assume that there's a presumption that the jury does follow the instructions they were given, and the law would suggest that.
Basically, your argument is that the jury factored all this in and basically gave him the damages that they thought that he was entitled to in light of all the lies and the misrepresentations.
Our argument is that the trial court didn't abuse its discretion, and the way this trial played out, what the jury ultimately did, and given the fact the trial court reserved on it, goes to that decision, goes to the ultimate exercise of discretion in this case.
How many lies is okay?
Your Honor, no one is condoning or suggesting that, but that's not the issue. The issue is not drawing a line about how many lies is okay.
Nobody here is pointing any fingers at any lawyers in the case. It's about the plaintiff.
Yes.
He made his nest, and we'll see what comes home to that nest. But, I mean, from what I hear from you, if the plaintiff tells every lie in the world about his case, which is almost what this guy did, the first part is undisputed. He was injured terribly, fault was admitted, all the rest of that. I mean, he had, as counsel pointed out, he had a pretty good case as it was, but then he decided he'd lie about his ability, his pain, his normal life and all the rest of that, lie about really everything he could think of to lie about, both in deposition and in many cases to the doctors. In fact, one time when it was pointed out he was being truthful to the doctor and saying it didn't hurt, he then said, well, the doctor must not have put it in his records. I mean, how much lying is okay, and is the ultimate remedy? We'll let the jury sort it out, and if the jury thinks it's okay, then we say it's okay?
No, Your Honor. Again, there's no bright line that can be drawn. These cases are all fact-specific. There is no absence, we would suggest, of a scheme as suggested by this court's prior precedent. Nobody is suggesting it was appropriate, but the reality is, as virtually every case that's cited at this court stands for the proposition that the court has broad discretion in these matters. And again, the fact that it was not brought to the court's attention prior to trial, who knows?
But he didn't admit he lied before he got to trial, did he?
I'm sorry?
He did not admit.
He did not admit, no, he did not admit the lies prior to trial. But again, they could say, Judge, he committed a fraud on the court, here's the investigator, here's the videotape. We're not suggesting that was the only way this could have been done, but I think that they have to also live to a certain extent with their choice to wait till the middle of trial to bring this to the trial court's attention, give the court a couple cases, and then the trial court has a thoughtful decision afterward, not objected to, after the jury brings it back, and can this court say, again, based on this court's cases, except in the most extreme cases, factual inconsistencies, even false statements are well managed through impeachment. And then again, in Perrine, courts talking about the Florida Constitution balancing your right to trial versus this. Even lying can be managed through cross-examination. The court was aware of the cross-examination. The court put in its order that it was thorough and it was extremely effective. The jury heard all the lies and heard all this material. Are we going to say at that point the trial court abused its discretion by not saying, sorry, you've lost your day in court, I'm imposing the ultimate sanction? We've spent all this time impaneling this jury, you've cross-examined this person, they've heard everything, they're going to do what they're going to do. I'm going to give this person his day in court. That's the question.
But if this case had come up in Dade County rather than Orange County, you think the outcome might have been different based on the case law that's out there, what the third DCA
I
is?
think that I'm suggesting that a trial court who is making a decision is going to look at the case law that controls from that district, and I think that this court's clear line of cases, starting with Cox, which then sort of opened the floodgates, if you will, to dismissal on these grounds for fraud, and then pulling it back repeatedly and saying, this is an extraordinary remedy, and we didn't mean to do that. We're going to reverse in Ruiz because you shouldn't have gone that far. There is a constitutional right to your day in court. This can be managed through exactly what happened here, thorough and extensive cross-examination. And, you know, as Judge Sawaya suggests, there was nothing wrong with the judge saying, I'm offended by this. I'm going to wait and see what the jury does. And if the jury did something, and again, we can all speculate as to why they did it, but the reality is they gave 60% of what was asked for.
I'm still stumped about how the jury did what they did after listening. They seem to indicate that the jury was prepped in voir dire and from...
It was a feature of the case. Everyone knew it.
There are going to be lies. He didn't tell the truth, and are you going to be able to factor that in and render a fair and impartial verdict? And so it seems like their argument is that the jury was prepped for all this and kind of...
Well, let's look at what the jury actually did. There was no dispute, and one of the things that this court has to consider in thinking about these issues is they admitted to the trial court that the issue of the property damage and the medicals were not in dispute, and these lies didn't go to those. And again, they seem to have changed their tack on appeal and saying, give them nothing. When they told the trial court, of course you have to give them those.
I think they're asking for the ultimate sanction, which is,
right,
dismiss the lawsuit, even the legitimate claims in the lawsuit.
They asked for that, but they also acknowledged to the trial court these lies did not go to those other measures of damages. The measure of damages for past earnings, they gave I don't remember what percentage it was, somewhere around half of what was asked for there, and they gave some past suffering, pain and suffering damages, which undeniably he had pain and suffering based on the injuries he sustained. They gave him 0 for future pain and suffering. So what did the jury do? That's what they did here. Is it unreasonable for what the jury did? We can speculate about that, but the jury gets to make that call.
This is a concern with regard to this, what appears to me to be, we got the lies, obviously, pre-trial. Even it appeared after, the third deposition was after the videotapes, and he continued
Absolutely.
even to be untruthful in the third deposition. And then you have what appears to be a trial strategy from jury selection through the end of let's throw ourselves on the sword with regard to these lies, and let's try to justify it from the and that was that's all counsel could do. And then even how dare these people follow him around and whatnot. And so it appears to me to be lie, beg for forgiveness, and then let's just see what the jury does in the end. And that's it's troubling.
The lies prior to trial were troubling, but I wouldn't suggest the strategy was that. I suggest the strategy was tell the truth at trial. And again, if this was a case where he continued to lie...
Tell the truth in the third deposition.
Your Honor, none of us can speculate as to Mr. Ortega's motives for testifying as he did. But ultimately, coming forward and telling the truth at trial, if he had continued to lie during trial, would the sanction have been appropriate then? And could there have been a scheme and a fraud? This case is slightly different in the fact that he did tell the truth. And if we're suggesting that the ultimate desire to have the truth be brought forward to the jury, somehow that policy should not be encouraged here, that's the other side of your argument. I understand your argument, and there are two sides to this. But the reality is, for whatever, it played out the way it did, and to suggest that when the thorough cross-examination. These lies are exposed. The jury gets to hear all the facts. It suggests that they should not have had the ability to do that, that his lies rose to such a level that he could not have his day in court guaranteed by the Constitution, that the ultimate sanction should have been imposed.
Employed an investigator to go out and follow Mr. Ortega around,
Yes.
then he would have continued to perpetuate the lie, presumably. Nobody would have, there would be no evidence that what he had said in deposition 1, 2, and 3 was false, and that the whole purpose of the sanctions in these types of cases is to prevent, a defendant from having to go out and do those types of investigations, and I believe Cox speaks to that.
And there are cases from other districts, and cases are legion, talking about and imposing the sanction, and then the appellate court saying, the court didn't abuse its discretion by dismissing these claims. And there are lots of cases where the investigators have come forward and had an evidentiary hearing and said, look, here's what's going on, case is done. The appellate court says, hey, we're not going to, that's a discretionary call. This case is slightly different for a variety of reasons. And again, the overriding principle being discretion.
Are you saying it's basically different because he didn't lie to the jury during the trial? He told the truth during the trial?
He told the truth at that point.
He lied in pre-trial.
We think, again, to sum up, there's a lack of a scheme. You didn't cover up, again, hide doctors and hide medical records and hide prior injuries.
Are you saying that that's a distinguishing feature?
I'm saying that is a distinguishing feature, that the fact they waited to get to the middle of trial, the jury heard all this, there was cross-examination, he did tell the truth at trial, the court did reserve, and the jury apparently, for some, it can be at least perhaps in the trial court's opinion, reflected in their verdict what they heard during trial. Under these facts, under these circumstances, we're not condoning it, no one is, it is not an abuse of discretion for the trial court to have waited and entered a detailed, carefully worded order based on this court's prior precedent to uphold the jury verdict.
Your time's about.
Thank you very much.
Okay, thank you. Okay, did he lie during the trial?
Absolutely.
Okay, what did he do to lie during the trial? Because
during the trial.
Okay, according to Mr. Carlisle, basically, he's saying that I admitted I lied in my depositions, but I'm going to tell you the truth during the trial. If he didn't lie during the trial.
Well, Your Honor, here's the danger. Here are some of the claims.
Tell me the lies that he told during the trial.
Well, I'll tell you why we don't know whether he lied or not. One was his retirement aid when he said he was going to...
Hold on. You told me that, just a minute ago, you told me that he lied during the trial, and now you're telling me you don't know whether he lied during the trial. Well, did he lie during the trial or not? Or did he tell the truth?
Your Honor, there were so many lies that no one can be assured that anything that came out of his mouth was truthful, and that is the bottom line.
Tell me what lie, I mean, you're asking us, I think you indicated before that he was injured, and that he did suffer some damages.
Yes.
And now you're saying that because of his lies that he told in his deposition, that we should take all that away, and that the verdict is wrong, the trial judge was wrong, and didn't properly exercise his discretion. All right. And so we know he lied in his depositions numerous times and multiple times, and he lied about elements of the cause of action, I mean, really important things. But I want to know what lies he told during the trial, or whether he was being truthful during the trial.
I'll have to repeat, Your Honor, we do not know whether he was truthful during the trial because we could not take anything he said or believe that anything he said was truthful. He made claims regarding his retirement age, his plans...
Wait a minute, now you're the one that it's your burden to show to us that the trial judge abused his discretion. And therefore, it's your burden to show us that the trial judge abused his discretion because this individual lied. We know he lied during pretrial. Is that sufficient to take away the verdict and the damages that he may be actually entitled to when he actually told the truth to the jury and to the trial judge during the trial? So if you're saying that it's just enough that he lied pre-trial, but he told the truth during the trial,
it is
one thing. But if you're saying that he lied during the trial, tell me. And if you don't know that he lied during the trial, you don't know.
We don't know whether he lied during the trial, Your Honor.
All right.
Was there, and without going back and rereading his testimony, did he say anything in his direct examination that you later impeached him with during cross-examination? Or did he throw himself on the sword completely in direct examination? Or do you...
He hedged a little bit on some questions, Your Honor, but for the most part, he admitted to his lies during the trial.
Okay, so let me ask a question a different way. If you can establish that he lied during the trial, I say I'm going to presume that he told the truth during the trial, as Mr. Carlisle has argued. Right. And if we say that he told the truth during the trial, and he admitted that in his depositions he misstated, he lied, and all this other stuff, and he told all that to the jury, and he was up front with the jury, and was up front with the judge during the trial, didn't lie during the trial proceedings, is it enough for us to say that simply because he told the lies pre-trial but was honest during the trial, that we need to take everything away anyway?
Yes, Your Honor, because what he did was throw away 3 years' worth of discovery efforts, resources of this defendant to pursue and to have to go forward and try to uncover those lies.
Your discovery was fruitful because it caused him to admit to the trial judge and to the jury that he was dishonest during pretrial. So, according to Mr. Carlisle, the jury apparently took that into consideration, gave him nothing for future pain and suffering, and gave him a reduced amount of damages that he actually asked for during the trial.
Yes, we don't know what the jury considered. We weren't in that room, but I think the language of this court, and time is limited, is very clear. A system that is designed to uncover falsehoods is doomed for failure.
Do you have a case, Mr. Carlisle seems to indicate this may be a little bit unique. Do you have a case where there's no doubt that, I mean, he told lies in his deposition, under oath, during pretrial, but then during the course of the trial, he came clean and he admitted that he had lied before, and then there's nothing to indicate that he lied during the trial and that he told the truth during the trial. And then the trial judge, according to the appellate court, still abused his discretion in failing to render a verdict in favor of the defendant based on the pretrial lies. Do you have a case like that?
I believe the Dade County case is very similar in that regard.
Okay, so the Dade County case is a case where he lied pre-trial but then told the truth during the trial and didn't lie during the trial.
There was no case where there's a direct admission during trial of lies. There's the case of the Hananu, which was afterwards, where he admitted to perjury, and the trial court after that said, well, let's have a new trial at that point and consider those lies, and the appellate court said, no, when you lie to that degree and you admit it, our duty is to protect the integrity of our judicial system, and you lose your day in court. And remember, that was an admitted liability claim as well.
And Murphy pled guilty to perjury not at trial, but perjury in his deposition?
Perjury after trial, he pled guilty.
I understand. After the trial was over, he pled guilty to perjury.
Correct.
But the perjury he pled guilty to was in his deposition.
That is correct.
He didn't admit to perjury during the trial.
That is correct. That's my
Testimony under oath that was false was during his pretrial deposition.
That is clear in the case, yes, Your Honor.
Just like Mr. Ortega has admitted lying repeatedly in his depositions in this case.
To the two central issues of this case.
But getting back to my question, I'm trying to determine whether there are appellate decisions out there that, you know, that say that the trial judge abused his discretion based on pretrial lies, but during the course of the trial, the admitted pretrial liar did not lie during the course of the trial and then told the truth, and then the trial judge abused his discretion.
Right. I'm not aware of any appellate decision on those specific facts.
Would this be the first?
I believe under these specific facts where a plaintiff admits during trial that they lied, and consideration of those specific...
So in other words, this will kind of set a precedent where during the course of the trial, he told the truth and admitted that pre-trial he did not, was up front with the jury, didn't tell any lies during the trial, but yet, and despite the fact that the trial judge didn't grant the directed verdict based on those lies, that the appellate court will say, well, based on the pre-trial lies he told, you know, that should have been dismissed despite the fact that he told the truth during the trial.
But it's more than that, Your Honor.
No, but is this going to be the first opinion or not? It sounds like it's going to be.
From my review of the case line, I reviewed thoroughly. Yes, Your Honor.
Okay.
But just very briefly, the court was...
Your time is up, so yeah, you wrap it up real quick.
Okay, well, Your Honor, then I'll be done. Thank you very much.
Okay, thank you.